Sure. My name is Neal Katyal, and I'm a law partner at Hogan Lovells, where I co-direct our appellate practice, and I'm also a law professor at Georgetown. Sure. So I was a law clerk in the 1996 term, which had a lot of constitutional issues, and I was fortunate to clerk for Justice Breyer. Remarkable individual, so quick, so fast, and your mind had to keep up with him, and that was a hard thing to do. But I loved it, and I loved, not just experience of working with him, but working with my co-clerks and the other clerks in the building. I think that whole set of experiences is really something to be treasured. Now, many of those justices have left the court at this point in time. And so, I've been fortunate. I worked for the Chief Justice here at Hogan Lovells and worked for Elena Kagan as her deputy. And now those are more recent experiences that I do use as I think about kind of what the justices are like and how receptive they are to a particular argument. Having spent a lot of time with them does help a little bit. I'm not going to say it gives me any sort of special advantage, but at the end of the day, one of the things I'm constantly asking is how are each of the 9 justices going to think about this case, not from the lens of what everyone says and an ideological filter, but really down deep. What are the kind of questions that they're going to ask? Well, I do think practically, yes, it's really important to walk into that court and understand the way each justice thinks and to do so in a way that you haven't approached this from some ideological filter or echo chamber, but really from reading their opinions, studying everything you know about them, and bringing it to bear. And we do that. Every single justice, I'm sitting there thinking, what are the points in my favor that I can use with every single one of them? What are the things that they're most going to hate about my client's case? And how do I try and accommodate that tension? So I joined the Georgetown faculty in 1997. I think I got tenure in 2001, and it's a great, great privilege to teach there and have students, a lot of students. My classes are big. I think the most important thing is, unfortunately, the legal academy today, law schools today, have gotten so theoretical. And certainly there's a role for it, but that there aren't very many of us practicing lawyers teaching in the law schools today. And that's why my classes are so oversubscribed, I think. It's not because I'm a particularly good teacher. I hope I am, but I'm not sure that that's it. It's because there are people yearning to actually know how to be a lawyer. And law schools are really good today, particularly the top law schools, at teaching 18th century German philosophy, not so good at teaching people what really the nitty-gritty of being a lawyer is about, how it works, and how that practical experience can influence both the theoretical side of teaching, theoretical side of scholarship, as well as the practicalities of teaching. And to me, that's the most fulfilling part of my job. And so, for example, I've been talking a lot today about how you approach things in a non-ideological way. If you teach that way, too, if you're really trying to see both sides of an issue and put it forth, that really opens up doors to students who otherwise would see things in a more monolithic fashion. And I view that as kind of my duty as a teacher to really bring that out. And so sometimes my evaluations say, guy's too conservative. Sometimes I say, guy's too liberal. And it's a really funny thing, but your job is really not to be either of those, but your job is, in many ways, just like to be an advocate, is to really see both sides of an issue and to forward the discussion. Yeah, so certainly sometimes when I'm doing a big case, my students have expectations that I have a certain view, and boy, they're a little, I try and encourage them to say the other thing, but sometimes it's hard. So sometimes I brought people in. So during the Affordable Care Act, when I was teaching constitutional law, and I had litigated and argued the case in all the courts of appeals, I brought in Paul Clement, who had just argued it in the Supreme Court, because I wanted to make sure I couldn't really pierce that fully. I mean, I knew that the students were going to be worried about that. So my obligation at that point to my students was bring someone in on the other side. And I try and do that with regularity to try and make sure that they feel like they've had a good balanced discussion of a really hard issue. Well, I've been on both sides of this cameras issue. I mean, I understand the justices and both their security concerns and their concerns that arguments are going to get spliced up and misrepresented and so on. But look, at the end of the day, this is the people's court. and there are 400 seats in that courtroom. I often can't get a seat in a hot button case, and certainly the majority of the American public can't. And it's one thing if they're just deciding issues of bankruptcy law or something like that, but when they are discussing and deciding the most momentous questions of the day, be it abortion or the death penalty or gay marriage or whatever, I think that my personal view is that that court should be open and viewed by the American public at large.